Hello friends, welcome back to another important video. Now just imagine you are a branch manager and a high net worth customer walks into your cabin with a big problem. He has lost his fixed deposit receipt worth rupees 10 lakhs and wants a duplicate issued immediately. What will you do? Immediately issue a new one? But what if the original is found and misused? Friends, that's where the power of a contract of indemnity comes in. Please note, as a banker, you deal with indemnities more than you realize. And if you are preparing for the principles paper of JAIIB, then this is a concept you should not miss. So stick till end of this lecture and I will simplify indemnity contracts in a way that will make you feel exam ready and also confident in your daily banking. Not only this, we will also do some conceptual exam level questions towards end of this video. So let's start with the basics. Friends, the indemnity basically means to make good a loss and is defined in section 124 of Indian Contracts Act 1872 as a contract where one party promises to save the other from loss caused by him or any other person. You can understand this in more simplified way with these examples. Now, example 1 is where a fire insurance policy indemnifies a shopkeeper against fire losses. The next is a bank indemnity bond protects you, the bankers, against the risk like issuing duplicate FDRs or demand drafts. So if a customer loses a demand draft, then the bank issues a new one only after taking an indemnity bond so that if the original is misused, then the bank is not held liable. Next, what makes a contract an indemnity contract? Friends, in an indemnity contract, there are basically two parties. First is indemnifier, which is the one who promises to compensate. And second party is called indemnified, which is the one protected from the loss. Next, friends, the contracts of indemnity are of contingent nature. That is, performance depends upon an uncertain event like loss or damage occurring. And lastly, these are one-sided obligations. So please understand that, unlike contract of guarantee, which involves three parties, indemnity has only one promisor. Next, friends, many bankers confuse indemnity with bank guarantees. So let's understand the difference, and also it's very important for your principles paper as well. Now the first feature is that of number of parties. Now in the contract of indemnity, as we have seen earlier, that there are two parties, that is indemnifier and indemnified. Then next, in contract of guarantee, there are three parties, that is creditor, debtor and surety. The next, with respect to nature of risk, in contract of indemnity, the risk is contingent, that is, it arises on the loss, while on the other hand, in case of contract of guarantee, it is secondary in nature, that is, surety's liability is conditional here. The next feature is contracts involved. Now in contract of indemnity, the contract involved is only one, while in case of contract of guarantee, the contracts are basically three. That is, debtor creditor, surety creditor and lastly surety debtor. The next, with respect to purpose, the purpose of indemnity is basically compensation for a loss, while the purpose of guarantee is security for the creditor. And lastly, example of contract of indemnity is bank issuing a duplicate demand draft, while for the bank guarantee, it's bank guarantee for a loan repayment. Now friends, before moving ahead with the lecture, don't forget to get your JAIIB resources from the links given in description of this video. All these are hard copy 1000 series question banks of all the 4 papers of JAIIB delivered straight to your location, be it urban or rural location, without any shipping charges. All the question banks comes with lots of numericals, case studies and questions which are very important for your examination. With this material, you get comprehensive exam level question practice, and that makes you best prepared for your coming JAIIB examination. I update all these question banks after every exam, so always get updated editions. All the links are there in description of this video, so do get these amazing hard copy books after you finish this lecture. Now let's continue with our lecture. So next, let's see the rights of indemnity holder. That is, when the indemnified party faces a lawsuit or what they can claim. So friends, section 125 of the Indian Contract Act grants the indemnity holder several rights. First is recovery of damages. That is, they can recover all the damages they are compelled to pay. Then second right is that of cost incurred. That is, they can recover cost incurred in defending a lawsuit. And lastly, with respect to sums paid under compromise. That is, they can recover sums paid under a compromise provided it was prudent and authorized. So friends, let's understand these rights with the help of an example. So suppose if a broker forges a customer signature on a government bond and sells it, and the buyer later sues the bank for issuing a fake bond, then the bank can invoke indemnity against the broker for all the damages it has incurred. Next friends, indemnity isn't always written. It can be implied as well. So please remember, indemnity is not always explicit. It can be implied based on certain circumstances. For example, if a broker endorses a promissory note with a forged note, then the bank can claim indemnity if it has acted in good faith. The next is, when does an indemnifier's liability start? So please remember, it is started the moment the loss is absolute, certain or imminent. That is, the indemnified party doesn't need to wait until they pass the loss. For example, if a bank issues a duplicate FDR and the original gets misused, then the customer must compensate the bank immediately. So friends, as you can see, banks use indemnities every day. And some practical examples are issuing duplicate demand drafts or FDR. Here the bank first take an indemnity bond from the customers and then issue duplicate DDs or FDRs. The next is death claim settlements. That is when legal heirs claim money from a deceased account holder. And lastly, with respect to locker agreements. So here also banks uses indemnity clauses in safe deposit locker operations. So friends, with this I hope the concept of contracts of indemnity is clear to you. Next, let's solve some application-based exam-oriented questions that will make this concept crystal clear to you. And the first question is from the concept of legal interpretation of indemnity contracts in banking. And the question goes like this. A nationalized bank issued a duplicate fixed deposit receipt to a customer who claimed to have lost the original. The customer signed an indemnity bond agreeing to compensate the bank if the original FDR surfaced later and was misused. However, a third party fraudulently encashed the original FDR and the bank suffered a loss. In this case, how should the bank legally enforce the indemnity bond? And the options given are these. That is, the first option is the bank must prove that the customer had fraudulent intent before invoking indemnity. Then second option B is the bank cannot invoke indemnity unless the customer personally misused the FDR. Then third option C is the bank can claim indemnity only after exhausting all legal actions against the third party who encashed the original FDR. And last option D is the bank can invoke the indemnity bond immediately as the customer's liability arises once the bank faces an absolute loss. Now friends, as we have learned earlier in the theory part that as per section 124, indemnity covers loss caused by the conduct of the indemnifier or any third party. Then next we have also seen that the liability of an indemnifier arises when the loss is absolute, certain or imminent. And we also know that banks routinely issue indemnity bonds before processing duplicate FDRs, DDs or traveler's check to mitigate such risk. So as far as this question goes, the correct option for the given question is option D. The next question is from the concept of implied indemnity in banking transactions, and the question is, a bank mistakenly clears a forged check of Rs 5 lakh in good faith, believing it to be genuine. The true owner later sues the bank for unauthorized payment. The bank in return sues the account holder who has deposited the forged check seeking indemnity. Which of the following legal principles support the bank's claim? And these options are given to you. That is, first option is the bank has an automatic right to recover the amount under an express indemnity contract. Then second option B is this is the case of implied indemnity, where the liability arises from the business conduct even without an express agreement. Then third option C is the bank cannot claim indemnity unless it proves negligence on the depositor's part. And last option D is indemnity is not applicable in cases of check frauds unless specifically mentioned in the deposit agreement. Now friends, the correct option for the given question is option B. As we have learned earlier in the lecture that implied indemnity applies where a party, now in our case the bank, incurs liability due to another party's, that is the depositor's conduct, even if no written indemnity contract exists. Also note, banks are protected under section 125, which allows recovery of damages in cases where indemnity is implied by business conduct. So you the bankers must understand that indemnity can exist without an explicit contract, especially in check clearances, fraud and forgery cases. The next question is from the concept of enforceability of indemnity in bank guarantees. And the question is, a customer applies for a bank guarantee from the state bank to secure a business contract. The bank agrees, but only after the company executes an indemnity bond. Later, the company defaults and the bank has to pay the guaranteed amount. Under what conditions can the state bank immediately enforce indemnity against the company? And these options are given to you. Now, the first option is only after proving in the court that the company's financial position is incapable of repayment. Then second option B is only after exhausting all attempts to recover the loss from the party who invoked the bank guarantee. And third option C is only if company provided collateral equivalent to the guarantee amount. And last option D is as soon as the bank fulfills its guarantee obligations and suffers financial loss. So friends, please note indemnity in bank guarantees ensures that the issuing bank does not suffer losses due to default by the applicant. The next section 124 stated that indemnity liability begins when the indemnified party's loss is certain and not after prolonged legal proceedings. So as far as this question goes, the correct option is option D. Lastly, also note, banks require indemnity bond from companies before issuing bank guarantees to protect themselves from financial exposures. So the key learning for you is that bankers must ensure indemnity bonds are properly executed before issuing financial instruments like bank guarantees, as they provide immediate recovery rights. The next question is from the concept risk management in indemnity contracts for banks. And the question is, a bank loses a demand draft issued to a customer and on the customer's request issues a duplicate DD after obtaining an indemnity bond. Later, the original DD is found and fraudulently encashed by a third party. The customer refuses to honor the indemnity bond, arguing that he did not misuse the DD himself. What is the most appropriate legal argument the bank can make to enforce the indemnity bond? And these options are given to you. That is, first option is, the customer is liable because indemnity contracts cover all consequences of the event regardless of who misused the DD. The next option B is the customer is liable only if the bank can prove that he personally benefited from the misuse of the original DD. Then third option C is the bank cannot enforce indemnity because the loss was caused by a third party and not the customer. And the last option D is the bank should first file a police complaint before enforcing the indemnity bond. Now friends, the correct option for the given question is option A. As you know, indemnity agreement protects bank from all the losses arising from an uncertain event, even if caused by a third party. So in the given question, the indemnifier, that is the customer, has promised to cover losses from the duplicate DD issuance regardless of personal involvement in the misuse. And the key learning for you bankers is that banks should always obtain well-drafted indemnity agreements when issuing duplicate financial instruments to mitigate fraud risk. So friends, let's do a final question before winding up this lecture. And this last question is from the concept of contingent nature of indemnity contracts in banking. And the question goes like this. A bank signs an indemnity contract with an asset reconstruction company while selling non-performing assets. The contract states that if any of the sold goods are later found to be fraudulently originated, the bank will indemnify the asset reconstruction company against legal liabilities. In this case, the bank's indemnity obligation is, and these options are given to you. That is, first option is absolute and unforeseeable immediately upon contract signing. Then second option B is contingent and enforceable only if fraudulent nature of the loans is proven. Then third option C is limited only to the first year after the NPA transaction. Then last option D is unenforceable because fraud cannot be covered under indemnity contracts. Friends, as we have learned in the theory that indemnity contracts are contingent in nature. That means they are enforceable only when a specific event occurs. So in the given question, the bank is not immediately liable but must indemnify the asset reconstruction company, that is ARC, if the fraudulent loan origination is proven. Also note, banking indemnity contracts in NPA transactions often have conditional clauses that trigger liability based on audit findings. So as far as this question goes, the correct option is option B. Friends, I hope you found the lecture beneficial. If so, then do like this video and also subscribe this channel. You will get lots of quality content before your examination. Also, don't miss to get your JAIIB resources from the links given in description of this lecture. So thank you, and I will meet you again in another video next week.